Ladies and gentlemen, back at you with another video. Katlego Moagi of Citizen Concerned has dropped a video enkgang masepa amagoa ako Orania.
If Orania is racist, then let them be racist as long as they pay their taxes. They chose to live together as a community according to their rules. It is their private property and it is their right. Just leave them alone. The people of Orania may be racist. I don't know. And I don't care. Why? Because it's their land. They're not doing it on public property that my taxes contribute to. It's their land and they should be allowed to do as they please on their land.
And you will be watching that video all by yourself on her channel over there. In that video, she is having to twerk very hard for Dzedzi. The Orania thing, that Orania place is under siege by the EFF.
Onto this now. The EFF in the Northern Cape marched to the offices of the province's premier demanding a review of the existence of Orania. The party says settlements such as Orania have no place in a democratic South Africa. This comes a day after the MK party officials visited another whites-only settlement called Kleinfontein in what they described as a fact-checking mission.
Kleinfontein in Pretoria is also under siege by the MK.
A small enclave of 1,500 Afrikaners only in Kleinfontein has denied that it's trying to create an Orania in Tshwane. MK Party Chief Whip in the National Assembly, Mzwanele Manyi, went on an oversight fact-finding mission on the Kleinfontein community.
So those who stand for Afrikaner privilege are having to twerk extra hard right now for that money. As you go and watch that video, you will see that she also quotes Ike Khumalo, another well-known right-wing coon.
Orania started around the same time as democracy in this country, but look at it now compared to the rest of the nation.
Whenever the ANC, they're running out of shit to say, they always bring Orania, 2,000 people living in a farm. How is Orania responsible for black lives? How is Orania responsible for black poverty in South Africa?
And together, they tried to also rope in Malcolm X into this defense of Orania. Like I say, ke masepa magoa ako Orania ankga all over this video, and you'll go and watch it for yourself. Now, in this video, you will be reading something that I've done research and compiled for you. It is research, it is a report into the possibility of challenging Orania constitutionally. This is far better than anything Katlego could come up with. As you will find in her video, she just goes and goes and goes and goes on a strawman argument about how people want to go live in that shit-ass place, dusty-ass, bum-ass town called Orania over there. And the truth is that nobody really wants to do that. And as you are shaming people, pretending that they want to live there and they can't build for themselves, yada yada, you really are showing that you're not as smart as you think you are. You are, in fact, dumb as a rock. You have no reasons to defend your position, or rather your employers' positions, the people who hire your mouth. And so you had to go on an ad hominem attack of black people, etc., etc. So here I am challenging you with some well and properly written research. Ladies and gentlemen, have a look now as I will be reading you the material that I've put together for you. Make sure to listen to it all the way to the end. Share it with people who need to know it. I will maybe be doing a video where I'm actually reacting to Katlego's video to further debunk and expose her for the cheap charlatan trash that she is. So let's get into the stuff right now. Here goes. Legal analysis of Orania's admissions policy and the South African Constitution. Introduction and background. Orania is a self-described Afrikaner-only community in the Northern Cape of South Africa, often characterized as a whites-only town. Established in 1991 by Afrikaners, including the family of Apartheid architect Hendrik Verwoerd, Orania's founders sought an enclave where Afrikaner culture and language could be preserved in the post-apartheid era. The town's admission policy effectively restricts residency to white Afrikaans speakers. Prospective residents must demonstrate fidelity to Afrikaner language and culture and even pledge to employ only white Afrikaners. Although Orania officials deny overt racism, this policy excludes black people and other groups from living in the town. Orania operates as a private share block company, owning all the land with residents as shareholders rather than freehold owners. This structure allows vetting of all residents and tight control over who may buy shares and thus reside in Orania. The constitutional question is whether Orania's race-exclusive admissions policy can withstand scrutiny under South Africa's post-1994 legal framework. The Constitution of the Republic of South Africa, 1996, enshrines equality and non-racialism as foundational values, Section 1, and includes a Bill of Rights guaranteeing equal protection and non-discrimination, Section 9, and freedom of association, Section 18, among other rights. Orania's leaders often invoke the right of cultural self-determination in their defense, pointing to constitutional provisions that recognize community rights, Section 30 and 31, and even a special clause on self-determination, Section 235. At the same time, critics argue that Orania's practices amount to apartheid-like racial segregation that is fundamentally at odds with the Constitution's vision of an inclusive, non-racial society. This report analyzes the relevant law, particularly the Equality Clause, Section 9, of the Freedom of Association Clause, Section 18, and examines whether Orania's de facto exclusion of black people could be deemed unconstitutional if challenged in court. We also consider concepts of indirect discrimination, relevant case law, and the findings or commentary from bodies like the South African Human Rights Commission and constitutional scholars. The Equality Clause, Section 9, and non-discrimination. Section 9 of the Constitution guarantees equality before the law and prohibits unfair discrimination by both the state and private parties. In particular, Section 9(3) and 4 forbid direct or indirect unfair discrimination or enumerated grounds including race, ethnic or social origin, culture, and language. This means that facially neutral criteria that function to exclude a racial group can still violate the Equality Clause as indirect discrimination. Orania's admissions policy, requiring adherence to Afrikaner culture and Afrikaans language, is a prime example of indirect racial discrimination. On its face, the policy is couched in cultural terms, but in effect, it ensures only white Afrikaner people qualify. Thus, no blacks are allowed to settle in Orania. South African courts have recognized that such ostensibly race-neutral rules can amount to racial discrimination if their impact is to disadvantage a particular race group, as established in City Council of Pretoria versus Walker 1998, 2, South Africa 363 CC, among other cases. Under Section 9(5) of the Constitution, discrimination on a listed grounds like race is presumed to be unfair, placing the onus on the respondent, in this case Orania or its controlling entities, to prove that discrimination is fair or justified. Importantly, the Constitution's equality guarantee applies horizontally to private conduct. Section 9(4) mandates national legislation to prevent or prohibit unfair discrimination by private persons. Parliament gave effect to this through the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000. Under the Promotion of Equality and Prevention of Unfair Discrimination, no person may unfairly discriminate on grounds including race, and victims of discrimination can seek redress in equality courts. Orania's practice of refusing residency or property ownership to black applicants would almost certainly constitute unfair racial discrimination under this act, unless they could establish a valid exemption or defense. There is no obvious exemption here. Unlike certain narrow allowances, for example, bona fide religious institutions limiting clergy positions to persons of that religion, or affirmative action measures under Section 9.2 for disadvantaged groups, Orania's policy is designed to exclude the historically disadvantaged majority rather than advance them. In evaluating unfairness, South African courts considered factors such as the position of the complainants in society, the purpose and effect of the discrimination, and whether it impairs dignity. A black South African denied the right to live in a town because of race clearly suffers an affront to dignity and equality. Given South Africa's history, courts are especially alert to practices that perpetuate patterns of racial exclusion. In Pretoria versus Walker, for example, the Constitutional Court found indirect racial discrimination when a policy imposed higher service fees on a white neighborhood and lower fees on black townships. Even though race was not explicitly mentioned, the measure's effect was racially disparate and harmful. Orania's racial gating of an entire town is far more extreme. It effectively revives apartheid-style segregation, which is precisely what the Equality Clause aims to dismantle. Indeed, as one commentary notes, segregation remains illegal in South Africa, and Orania survives only by claiming a special constitutional niche. Any court review would start from the premise that racial exclusion is prima facie unlawful, and then examine if Orania's justifications can possibly render it fair or saved by other rights. Indirect racial discrimination in Orania's policy. Orania's defenders assert that race per se is not the criterion. They claim anyone who is an Afrikaner, defined by language, culture, and even religion, may join. However, South African law does not allow one to escape anti-discrimination norms by using cultural proxies for race. This is the essence of indirect discrimination. A rule like resident must be committed to Afrikaans language and white Afrikaner employment targets a cultural identity but produces an exclusionary racial outcome. The Equality Act explicitly covers direct discrimination, and courts will look at the real-world impact of a policy. Here the impact is undisputed. Only white people live in Orania, and black South Africans, or others not meeting the Afrikaner ethic criteria, have been prevented from buying property or residing there. In one notable incident, a black businessman, Andrew Shabalal, attempted to purchase a house in the Afrikaner-only enclave of Klipfontein, a community similar to Orania. The community's cooperative thwarted the sale by invoking a bylaw allowing a counter-offer on any property sale, explicitly to block a black buyer from moving in. This illustrates how seemingly neutral rules are wielded to maintain racial homogeneity. Under constitutional scrutiny, a court would likely find that Orania's admissions policy constitutes unfair indirect discrimination on the ground of race, and possibly on grounds of language and culture as well, since it discriminates against those who are not Afrikaans-speaking or of Afrikaner culture. The burden would then shift to Orania to justify its policy under the Limitations Clause, Section 36, or as a constitutionally permissible affirmative measure. Given that the policy's purpose is to exclude a formerly oppressed majority group, black South Africans, in order to preserve the privilege of a minority, it is hard to imagine a court accepting this as a fair or reasonable limitation in an open and democratic society. South African jurisprudence has consistently held that entrenching racial separation is antithetical to the Constitution's values. The Constitutional Court famously states that the Constitution is a bridge away from the dark past of apartheid to a future founded on equality, and it has struck down even direct or subtle forms of racial differentiation that perpetuate stigma or disadvantage. Freedom of association, Section 18, as a defense. Section 18 of the Constitution guarantees everyone the right to freedom of association. the liberty to form and join groups of one's choosing, Orania's community could argue that their town is essentially a voluntary association of like-minded people, a cultural collective, exercising this right. In a free society, people may form private clubs or organizations around shared values, and that often includes the ability to select members. To what extent can Orania claim to be a private association with the right to exclude non-members? There's a qualitative difference between a small private club and an entire town or settlement. Orania is not just a cultural club meeting in private. It is a territorial community exercising governmental functions. It has a mayor/CEO, makes municipal decisions, issues its own currency, etc. It provides housing, employment, schools, and services, essentially operating as a local municipality, albeit privately run. When an association takes on the characteristic of a town with public infrastructure and economic activity, its discriminatory membership rules have far-reaching impact on fundamental rights of others, such as the right to freedom of movement and residence, equality, and dignity of those excluded. In South African constitutional law, no right is absolute, including freedom of association. Rights can be limited by law of general application under Section 36 and must be balanced against other rights. Moreover, the exercise of one right cannot nullify the core of another's rights. The question a court would face is whether Orania's interest in maintaining a private cultural enclave outweighs the fundamental right to equality of those excluded on racial grounds. Historically, South African courts have favored non-discrimination over private biases in analogous contexts. For instance, a private club or business cannot refuse services to customers on racial grounds, as this would be outlawed by equality legislation. Freedom of association would certainly allow Afrikaners to form cultural societies and institutions like churches, language boards, or cultural clubs. But when association is used to justify creating an exclusive geographic zone from which other citizens are barred, it treads into territory that looks like group segregation. The constitutional value of non-racialism, expressly stated in Section 1B of the Constitution, would weigh heavily against interpreting Section 18 to permit a racial enclave. In short, while Orania's residents are free to associate with one another to celebrate their culture, this does not give them a constitutional license to exclude others from living in a town in South Africa based on race. The right to associate cannot be a shield for violating the equality rights of outsiders. Notably, Section 21(3) of the Constitution provides that every citizen has the right to enter, remain in, and reside anywhere in the Republic. This freedom of movement and residence underlines that all South Africans should be able to live in any town or area, subject only to general law. Orania's policy effectively denies black citizens this right with respect to that geographic area. While a property owner can choose whom to invite onto their private home, when an entire town is privately owned to exclude others, it raises novel questions. A court would likely be sympathetic to the argument that Orania's collective exclusionary practice undermines the spirit of Section 21(3), even if technically framed as private property rights or association. In any event, even if freedom of association is implicated, a court must reconcile it with the equality guarantee. South Africa's Constitutional Court has often emphasized context and proportionality in resolving rights conflicts. Here, the context is a nation that has abolished institutionalized racial segregation. The constitutional project of nation building is predicated on integration and equality, not permanent segregation. Association rights would likely yield to the imperative of equality and non-racialism in this context. Cultural rights, Section 30 and 31, and self-determination, Section 235. Orania's founders and supporters frequently invoke the Constitution's recognition of cultural and language rights to defend its exclusivity. Section 30 of the Constitution says everyone has the right to use their language and participate in their cultural life. Section 31(1) specifically protects the rights of the members of a cultural or linguistic community to enjoy their culture, practice their religion, and use their language, and to form associations or other organs of civil society. On the face of it, these provisions affirm that Afrikaners, like any other group, may band together to celebrate and preserve their culture and language. Orania is often presented by its leaders as an exercise in cultural preservation, a safe haven for Afrikaner language, religion, and traditions in a country where they feel those are under threat. Indeed, Orania spokespersons argue that their goal is to preserve Afrikaner history and culture as an exercise of constitutionally protected rights. However, Section 30 and 31 have explicit internal limitations. Section 31(2) states that the rights in 1 may not be exercised in a manner inconsistent with any provision of the Bill of Rights. This is crucial. It means that while the Constitution protects cultural association, such activities cannot infringe on others' fundamental rights or violate principles like equality. The framers were mindful that invoking culture or religion must not be a pretext to undermine individual rights. For example, harmful traditional practices or discriminatory acts cannot be justified by culture. In the leading case of Christian Education South Africa versus Minister of Education 2004, South Africa 757, the Constitutional Court cited Section 31(2) in rejecting a religious schools association's attempts to use culture or religion rights to justify corporal punishment of students, a practice inconsistent with the children's rights and the values of human dignity. By analogy, an attempt to use cultural rights to justify racial exclusion in Orania would run into the Section 31(2) barrier. Denying an entire racial group the right to live in a community is plainly inconsistent with the equality rights of that group. Thus, Orania cannot rely on Section 30 or 31 to shield its admissions policy if that policy is found to be discriminatory. The Constitution itself makes clear that cultural autonomy is not a license to violate others' rights. Another unique provision often mentioned in the Orania debate is Section 235, the so-called Rights to Self-Determination Clause. Section 235 acknowledges that the South African people's right to self-determination as a whole does not preclude the possibility that any community sharing a common cultural and language heritage may claim a right to self-determination within a territorial entity in the Republic in terms of legislation provided by Parliament. This clause was a product of negotiations during the end of Apartheid, aimed at addressing demands for a Volksstaat, Afrikaner homeland. It is often cited as the constitutional basis for Orania's existence. Orania's leaders assert that their project is an expression of community self-determination, exercising the very rights Section 235 contemplates. In practice, however, Section 235 is not self-executing. It requires national legislation to give effect to any such territorial self-determination. To date, no law has been enacted to grant any community an autonomous homeland or special status under Section 235. Orania's autonomy is thus informal. It is technically not a town under ordinary municipal law, but a private enterprise. Section 235 was intended as a conciliatory gesture and has never been concretely implemented. Invoking it in court would raise complex questions. Does Orania constitute a community that can claim self-determination, and has it any legal standing without enabling legislation? Even if arguendo, Section 235 offers some constitutional recognition of Orania's aspirations, it cannot override fundamental rights. The Constitution's Supremacy Clause, Section 2, and the Bill of Rights suggest that any self-determination arrangement must still conform to the broader constitutional principles, including non-discrimination. Section 235 was not meant to constitutionalize apartheid-style separation. It was likely meant to benign forms of cultural self-governance negotiations through law and subject to the Constitution. Thus, relying on Section 235 would automatically save Orania's racial exclusion policy in court. At most, it might be an argument for a political solution or a special legislative compromise, not a trump of the Bill of Rights. As one analysis bluntly notes, Orania's survival under the Self-Determination Clause is a funny controversy, obscuring the fact that their experiment in exclusion must still answer to constitutional scrutiny. Precedents and official reactions. To date, no court has definitively ruled on the constitutionality of Orania's admissions policy. However, there are precedents and incidents that illuminate how a challenge might fare. High Court remapping case, early 2000s. In the early 2000s, during South Africa's municipal restructuring, the government's demarcation board planned to redraw local boundaries to incorporate Orania into a larger, democratically governed municipality. Orania's leadership viewed this as an existential threat to their self-governing project. They appealed to the courts, arguing that forcing Orania under a common municipality would violate their constitutional rights as a cultural minority. According to reports, Orania won a victory in the High Court, which accepted the argument based on the constitutional rights of the country's minority cultural groups and allowed Orania to retain its autonomous status. Essentially, the court permitted Orania to remain self-administered through its share block company and community council, rather than being fully subject to a broader municipal council. This outcome, which the ANC-led government apparently did not appeal, has enabled Orania to continue largely uncontested in terms of its governance. It's important to note, however, that this ruling did and did not decide. The High Court case was about governance and boundary integration, not a direct sanctioning of racial exclusion. The court likely focused on the procedural rights of the community to maintain a form of local government, perhaps viewing Orania as analogous to a private town or settlement association in light of constitutional protections for cultural communities. It did not explicitly endorse racial criteria for residency. It simply allowed Orania to stay separate at the time. The fact that the government chose not to appeal might have been political, avoiding a fight with Afrikaner conservatives in the early post-apartheid years, rather than an acceptance that Orania's racial exclusivity is constitutional. Anticipated Constitutional Court challenge circa 2013. The issue of whites-only enclaves surfaced again with Kleinfontein, another Afrikaner settlement near Pretoria, in 2013. When a black South African's attempt to buy property was thwarted, as noted above, public debate intensified. Media reports indicated that the Constitutional Court was expected to rule on whether such settlements can survive in their current form, which would have implications for Orania and others. This suggests that a legal challenge, perhaps by the excluded buyer or other parties, was making its way up. However, as of now, there has been no reported Constitutional Court judgment directly on Kleinfontein or Orania's exclusionary policies. It's possible the matter was settled or withdrawn or is still dormant. The lack of a clear precedent from the highest court means the question remains open, but the expectation of a Concord review itself signals that these practices raise serious constitutional questions. South African Human Rights Commission. The South African Human Rights Commission, a state institution tasked with promoting equality and investigating rights violations, has periodically been asked to weigh in on Orania. There have been public complaints and inquiries. For example, concerns about other areas becoming a mini Orania have been brought to the Commission. In 2019, The Premier of the Northern Cape, Dr. Zamani Saul, indicated that an inquiry into Orania's legal status was ongoing. Although details are sparse, this implies that authorities, possibly through the South African Human Rights Commission or a government task team, have been examining whether Orania's exclusivity is lawful. No official finding from the South African Human Rights Commission have been published at the time of writing that declare Orania's policy unconstitutional. The Commission would likely approach the issue under the Equality Act and could potentially initiate or support litigation if it found evidence of prohibited discrimination. Absent a test case, Orania exists in a legal grey area, not officially endorsed by any law or court, but also not yet struck down by any tribunal. Legal commentary and scholarly opinion. Constitutional scholars and commentators overwhelmingly view Orania's racially exclusive policy as in tension with South Africa's constitutional values. Tembeka Ngcukaitobi, a prominent constitutional lawyer and author, has argued that Orania represents the reversal of the constitutional project of nation building. Ngcukaitobi notes that while the rights invoked by Orania, cultural and self-determination rights, exist, the rights that underpinned Orania's High Court challenge are not unlimited. He opines that any South African committed to constitutional values would rightly be offended by what Orania represents, which is an enduring legacy of racial mobilization. This encapsulates the prevailing view that Orania is an anachronism under a constitution dedicated to non-racialism. Similarly, Urapileng Muraladi of the trade union COSATU described Orania as embracing an apartheid system within a democratic state, calling its continued existence an indictment of the government of South Africa. These statements, while not law, reflect a strong sentiment that Orania's model is fundamentally at odds with the Constitution's ethos, and that the state should not acquiesce to it indefinitely. On the other hand, supporters like Orania's own officials claim that they are doing nothing unconstitutional, framing it as cultural protection. They often point to the fact that Orania is peaceful and crime-free, implying a right to safety and community cohesion, albeit along segregated lines. They also note they do not explicitly forbid anyone by race in their founding documents. They simply require cultural compatibility. However, such justifications carry little weight legally if the outcome is racial exclusion. It is telling that no black person has ever been admitted as a resident of Orania in its decades of existence. This would be potent evidence in any court that the town's policy is discriminatory in effect regardless of intent. A potential test case could arise if, for instance, a black family applied to purchase shares in Orania's property company and was rejected due to not meeting the cultural, ethical criteria. That family could file a complaint under the Equality Act, bringing the issue before a court. The court would then have to directly confront the question: can a private town exclude people on grounds that essentially boil down to race and culture? And here's an analysis: the prospects of a constitutional challenge. Given the above, could a challenge to Orania's admission policy succeed? In a court of law, a challenger, example, an excluded black applicant or a public interest litigant, would have strong argument under the Equality Clause. They would show that Orania's policy discriminates on prohibited grounds such as race, ethnicity, language, and culture, and that this discrimination is not a benign or remedial measure, but one that entrenches racial separation and stigma. The burden would shift to Orania to justify this under Section 36, the General Limitations Test. The limitations test asks whether a law or conduct that limits a right is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account factors like the purpose of the limitation, its extent, and whether less restrictive means could achieve the purpose. Orania's likely justifications: preserving a minority culture, freedom of association, and historical self-determination pledges would be considered. Protecting cultural diversity is certainly a legitimate purpose in a multicultural nation. However, a court would question whether complete exclusion of others is a proportionate means of cultural preservation. Could Afrikaner language and culture not be maintained without banning Black South Africans from the town? There are many Afrikaner cultural organizations, schools, and institutions in South Africa that thrive without resorting to racial exclusion. It might also be argued that Afrikaners, while a cultural minority, are not a vulnerable or disadvantaged minority in need of protection from integration. They are economically and politically influential and enjoy the same rights as any citizens. By contrast, the policy's impact on the rights of Black South Africans is severe. It insults their dignity, harkens back to apartheid-era group areas, and balkanizes the country. The symbolic and practical harm of allowing a race-exclusive enclave to flourish is likely to outweigh the symbolic benefit to Afrikaner residents of total cultural homogeneity. South African courts, in line with international human rights norms, would likely insist that multicultural integration is a core goal, and any measure to exercise cultural rights must be accommodative rather than exclusionary. Additionally, the Constitution's Section 36 requires considering less restrictive means to achieve the purpose. Orania could achieve cultural preservation by, for example, promoting Afrikaans language education, maintaining Afrikaans as the town's primary language, and celebrating Afrikaner heritage without outright banning non-Afrikaners from residency. If a Black person who speaks Afrikaans and is willing to respect local customs wanted to join a community, excluding them serves no genuine cultural necessity. It only serves a racial preference. This undercuts the proportionality of the measure. A court might also draw on the value of Ubuntu and integration, themes prominent in South African jurisprudence, to say that true preservation of culture does not require isolation. In fact, many would argue that Afrikaner culture can survive and be respected within a united South Africa without resorting to exclusive enclaves. The Constitution's approach to diversity is unity in diversity, not segregation in the name of diversity. One challenge in practice might be enforcement. If a court declares the policy unconstitutional, what remedy follows? Potentially, an order could issue that Orania and its property company may not discriminatorily refuse the sale or occupancy of property on prohibited grounds. This might open the door for non-white citizens to move in if they wish. Or the court could strike down any internal rules or policies that make Afrikaner identity a condition of residence. Orania as a private entity might try to resist, example, by refusing to sell or by informal pressure. But a clear court precedent would render such actions illegal and subject to further legal actions or contempt. It's possible the state might then step in to ensure compliance, perhaps by asserting normal municipal authority over the area if needed to guarantee equal access. It's worth noting that political and social factors have so far made the government hesitant to confront Orania head-on. The ANC government, while officially committed to non-racialism, has sometimes tolerated Orania's existence, possibly to avoid martyrs or backlash. However, pressure is mounting from portions of society. The economic freedom fighters has vocally demanded action against Orania. If a court challenge were brought, it would force the issue into the judicial arena, where political calculations are less relevant and constitutional principle dominate. Considering precedent and principle, a carefully prepared challenge has a strong likelihood of success. As one legal scholar observes, the rights Orania relies on are not unlimited, and allowing Orania to persist unchallenged amounts to negating the constitutional project. The Constitution is ultimately supreme. Any law or conduct inconsistent with it is invalid. A court declaration that Orania's admissions policy is unconstitutional would align with South Africa's commitment to eradicate the vestiges of apartheid. It would affirm that no community, however well-intentioned in cultural terms, may erect a racial bar to resistance. And so the conclusion. In conclusion, Orania's admissions policy, which limits residency to a particular white Afrikaner cultural group, faces serious conflict with the South African Constitution's equality guarantee. Under Section 9, it amounts to indirect racial discrimination that is presumptively unfair and almost certainly cannot be justified in light of the Constitution's foundational commitment to non-racialism and human dignity. The freedom of association, Section 18, and cultural rights, Section 30 and 31, provide important protections for minority communities to preserve their identity, but they do not sanction violating others' rights to equality. Section 31(2) explicitly forbids exercising cultural rights in a way that contravenes the Bill of Rights, which would include racially exclusionary practices. While Orania points to the Self-Determination Clause, Section 235, as giving it a constitutional space, that clause has not been concretized by legislation and cannot supersede fundamental rights. If brought before a court, Orania's policy likely would be deemed unconstitutional unless the community radically transformed its approach. Past legal developments, such as Orania's early 2000s court victory, stopped short of endorsing racial exclusion, and no high-level court has yet faced the direct question. But the tide of legal opinion suggests impatience with the notion of a whites-only town in a democratic South Africa. As Ngcukaitobi and others note, Orania represents a throwback inconsistent with nation-building and equality. A successful challenge would reinforce that South Africa's constitution does not permit apartheid by another name, even under the guise of cultural preservation. In practical effect, Orania's policy can be struck down as unconstitutional, and such a result would uphold the principle that no community in South Africa can lawfully bar members of another race from its midst. And so, there we are. Hope you like, share, comment, and subscribe. Ladies and gentlemen, we are going to push, we are going to bring Orania to an end. It will come in our time, it will come in our generation, and dumbasses like Katlego are going to do nothing to stop it. I'll see you in the next one.